Hi, my name is Brian Forbes, and welcome to EDL 850, Module 12, presentation over tort law. So the first thing we want to think about is identifying what tort law is, also known as tort liability. And more or less, it basically says that there are consequences for people who partake in conduct or a lack of conduct that result in someone's injuries. And tort law or liability can be broken down into two different categories, the first of which is called intentional, and the second is known as negligence. So looking at intentional torts, that would be a case where you have someone who acts or intends to cause harm either to a person physically, mentally, or even through their reputation or to their property. So if you look at the illustration below, you'll notice that we have an individual who's throwing a rock at someone. Here, it would be reasonable to say that it would be within the realm of possibility that an injury could occur as a result of throwing the rock. Therefore, this individual intentionally attempted to do that person harm. The other tort, the negligent tort, basically happens when three things occur. Number one is called a breach of duty. The breach of duty says that every school personnel or person has a duty once they have a special relationship, in our case with students, and if you don't fulfill those duties in a reasonable manner, then you are in breach of your duty. Now, if you are in breach of duty, and the student ends up having some type of injury, again, physical, mental, reputation, or to their property, then there's something called a proximate cause if there is a direct link between your breach of duty and the injury. So in this case, if you look at the illustration, we have someone here dropping a basketball down from a high point into traffic. Now that person may not have meant to hit the car, but through their negligent actions or their breach of duty, knowing the right and wrong, if it actually results in the injury of the person driving the vehicle, and then they are in proximate cause, therefore causing that injury, they are found negligent. So let's look at some of the different torts in action through some 5 different court cases. The first court case is Mitchell versus Cedar Rapids Community Schools. In this situation, we have Mrs. Mitchell, who is suing the school district on the behalf of her daughter, D.E. Now, D.E. was a special education student who left campus slightly early to go home with another student, and that student actually ended up raping D.E. and D.E. told her mother quite some time later, but when the case was brought before the court did find in favor of Mrs. Mitchell and D.E. Now, the court pointed out a few different things in their verdict. Number one, that Kennedy High School failed to adequately supervise D.E. and did not fulfill their reasonable duties. Number two, they were in breach of duty by not contacting Mrs. Mitchell the moment D.E. was discovered to be absent. Instead, they waited, as was their policy, to make a phone call home after school hours. Number three, they did not abide by their duty to protect D.E. by properly maintaining adequate security on campus to prevent students such as D.E. from leaving during the school day. And then lastly, the Kennedy High School was connected through the proximate cause relationship of their failures and what ultimately happened to D.E., meaning that if any one of their duties would have been fulfilled, they could have prevented that injury from occurring. So looking at some of the reactive measures we could put in place here would be simply to make sure that the exterior doors to the building are locked, but while students, for emergency purposes, could get out from the inside, but we would want to attach alarms to those doors, so if a student did attempt to leave early through a non-authorized door, that an alarm would go off. That would prevent students from wanting to leave through that door, and that would also notify personnel that something was wrong. Now, some proactive measures would be that, especially for special education students or students with IEPs, that we have our paraeducators monitor those students in the hallways and escort them from class to class. Some ethical issues here would be that we need to have an adherence to attendance procedures all the time without question, and there needs to be a sense of urgency when taking attendance and reporting it so that we can find students that are truant. We need to remember that these students are in our care and we are in place of their parents in loco parentis, which means that those are our kids for all intents and purposes. And if one of our children were to go missing, we would want to find them right away. And so we need to return that favor to these students and their parents. Another court case is Johnson versus Millard School District. In this court case, we had a music teacher named Nancy Patton who was teaching some first grade students the song London Bridge, and was also showing them some physical activities where the students would lock arms and swing each other between two students. Even though she did warn the students not to misbehave and really stress safety with them, she actually turned her back to write some things on the board to prepare for the next activity. And in that moment, some of the students let go of another student named Robbie Johnson, and Robbie flew into a bookcase, cutting his face. So Robbie and his parents sued the school district, claiming that they were negligent. In this case, the judge actually did still rule in favor of Mrs. Johnson and Robbie Johnson. The court found that while Patton did give those instructions about safety issues, that Patton was negligent, meaning in the fact that she was in breach of duty, because a reasonable expectation for an educator would be to give an extended and direct supervision to those students, especially at such a young age, in an activity in a location where something could possibly go wrong. So some reactive measures here would be that physical activities, especially at the elementary school, need to have more than one person supervising. That is probably for the idea that if you have one person and they're distracted or get called away or something else occurs, an emergency, they are no longer effectively supervising that activity. So if you have two people and one of those things occurs, then the other person can still remain behind in order to supervise the activity. Some proactive measures would be to make sure that those physical activities, just like instructional practices, are included in lesson plans on a weekly basis that are reviewed either by a school specialist, a curriculum coach, an administrator, and also just for teachers to be able to reflect upon best practices so that they're actively thinking about safety as a part of their lessons. So some ethics here have to deal with the fact that educators need to always be aware of safety issues because, again, they are responsible for those children in loco parentis, and so it is our responsibility to take care of those students. The next court case, Mosley versus Portland Public Schools, is about a young girl named Chrisetta Mosley. She was a high school student who was in a fight during lunch where she was actually stabbed by another female student multiple times with box cutters. She ended up suing the school and the school district, claiming negligence on their part, that they didn't have adequate security personnel and that the security personnel they did have did not act swiftly enough to protect her. In this case, however, the judge in the court actually ruled in favor of the school district, claiming two things. Number one, that there was no way that the school district could have foreseen an issue as specific as this that would have required more security personnel, therefore they couldn't be held negligent in that regard. And then secondly, that the school security officers that were in place could not have acted any faster, and if they somehow were to have foreseen it and acted faster, would that have for sure prevented the particular injuries to Chrisetta? And the judge ruled that was not the case. So even though it ruled in favor of the district, what are some reactive measures? Well, like in my school, we only have one school resource officer, and it's actually shared with an elementary school close by. So we don't have a school security or resource officer every day, so we would want to get a full-time officer. And I could see that some school districts might want to include metal detectors or clear backpacks to ensure that students aren't bringing weapons into the building. A proactive measure here would be to make sure that staff are trained on how to properly supervise children in all aspects of the building. And then we want to make social and emotional standards an important part of our curriculum so that students can empathize with one another and they can learn how to overcome obstacles with one another in a nonviolent means. So some professional ethics to look at here would be that, again, we want educators to be aware of their surroundings for safety issues, but then we also want to make sure they're always incorporating those classroom management skills and techniques and procedures outside of the classroom as well, whether it's in the hallways or commons areas like the lunchroom. So we want to make sure that students are behaving themselves physically, that they're not being loud, that they're acting nicely to one another, and that they're following protocols that they've been given since day one. Okay, the next court case is Hoyam versus Manhattan Beach School District. In this case, we have a student named Michael Hoyam who ended up suing the Manhattan Beach School District. His family ended up helping sue them because they found that the school district was negligent and that Michael Hoyam left school during summer school. He left early and was actually struck crossing a crosswalk at an intersection by an individual on a motorcycle. So they argued that the school district was negligent and that they did not properly fulfill their duties to protect Michael. So in this case, the judge actually ruled in favor of Mr. Hoyam, unlike the previous court case, and they said three things. One, that the school and the district did not supervise Mr. Hoyam during summer school reasonably to an extent to prevent his truancy, meaning that attendance wasn't taken in a timely manner, that hall supervision was minimal to none, and that no one stopped him on his way out of the building. Two, they failed to contact Michael's parents to alert them that he was not at school anymore so that they could search for him as if he was a missing student. And then number three, that both 1 and 2 had a direct link and cause, so there was a proximate cause to Mr. Hoyam's injuries. So some reactive measures here would be, again, to have the doors locked with alarms on them so students can't leave during the school day. We would want some proactive measures in place to have protocols about contacting parents and the speed in which that occurs, and then moving that information to a school resource officer, especially if a student was present and then is no longer present at school. That should be taken more along the lines of an emergency. Some professional ethics to consider would be that teachers need to always perform duties, especially between classes, and monitoring in the halls is one of those duties, and that we should try and have somebody at whether school security or someone in the front office watching our CCTV, which is our closed circuit security cameras. The next court case, NM versus Anchorage School District, had a young student going by the initials NM to protect his anonymity. He was a kindergarten student who was excited to see his mother after school, so he went running towards her. Unfortunately, he tripped and fell, like many students do. Unfortunately for him, there were some shrubs where he fell that had recently been cut down, and so there were some barbs sticking out of the ground where it pierced him in the eye and actually into his brain, causing serious damage. The court eventually did rule in his favor, finding the Anchorage School District negligent on two things. It found that the Anchorage School District was negligent and that they did not properly maintain their facilities to a point that it would ensure the safety of students. And then number two, that there should be a reasonable expectation to fully remove objects from common areas such as this in order to prevent injuries, and then the district obviously failed to do so. So their failure to act at all caused their negligence. Some reactive measures here, if this would have happened in my building, would be to obviously go around the building and remove shrubs and small trees and other woody plants from common walking paths and replace them with softer materials like flowers. And then also, I could see that my administration might be so inclined to fire the maintenance worker or the entire grounds crew for their negligence or failing to deal with the situation, such as to properly remove the shrubs, including the barbs that were sticking out of the ground. Some proactive measures here would be to walk around the grounds at least once a week with a checklist identifying all the maintenance issues so that we can get on those quickly, and also so that there's evidence to show, in case of a court case like this, that we do take the building maintenance and the security of students seriously and that we work on it consistently. Some professional ethics of this case is to always make sure to carefully plan. Without careful planning, especially for a safe environment, accidents are more likely to happen. Employees need to be able to offer input on the safety violations or the concerns they see around the building freely. They shouldn't be afraid to share their opinions. And then the school needs to be able to promote and nurture the safety of students. So those are my 5 court cases and my discussion about tort law. So thank you all for watching, and I hope you all learned something.